With that background, which is correct, I want us to have a look at two issues. The issue of the pleadings. The Supreme Court, through several decisions, including the Dande case, has stated that you can have the remedy or the relief of judicial review either under the Constitution, as you stated, Article 23, or under the Order 53. And if you go under 53, you may be limited to the issue of procedural review if you do not invoke any allegations of constitutional violations or rights violations. But if you go post that and invoke constitutional provisions, the violations of the Constitution and the rights, then you may be, even under Order 53, you may be entitled to a merit review for that matter. That places JR under Order 53, same as JR under Article 23. But how different will be a pleading under Order 53 be from a constitutional petition in Article 23?
Thank you very much, Judge. Under Article 23, under Article 47 of the Constitution, and the Fair Administrative Act, and the Comey Rules of 2024, have entrenched JR as a judicial mechanism which is not subject to all the JR of the procedural restrictions of 6 months and leave. The question is whether, under these circumstances, the JR can issue merit review. Under Article 23.3, the orders which can be issued both under JR and under constitutional violations are indicated. And I think there are 4 or 5. But the court has said you can issue appropriate orders under JR and under constitutional violation. The restriction under JR 53, the question is, because of the Comey Rules and the Act, does it still subsist? It is still within the statute, Order 53. And I have seen people who have come under Order 53, and because of this, they have not obtained or they did not have the 6 months, their cases was dismissed. And again, I have also seen decisions of the Supreme Court, I think there are 4. The Dande, is it the Dande, which is equivalent to Geller vs. Kasman Brown, which was about propriety rights. The Supreme Court said, of course you can review merit, but under very limited circumstances. And the court enumerated those circumstances. But nonetheless, for example, in the case of Praxidis Namoni against JDC, the company secretary was saying, I did not participate in the tender. But nonetheless, the court said, no. These are issues of merit. Go back. Again, also in the case of Professor Tom Ojienda against the anti-corruption, the court also determined what is an administrative and said arrest, search, and surrender of documents does not fall within the purview of an administrative action. So
Judge, just for clarity, Am I understanding you to say that when you take the route of Order 53,
Yes.
regardless of what you plead, even if you plead all the rights and constitutional violation, as long as you do a pleading under Order 53, it must comply to the requirements of leave and the timelines?
Yes.
That still remains?
Yes.
And is that the case?
Yes.
Under constitutional petitions, under
No.
Article 23?
Yes. But usually there is a dilemma. The dilemma is under the Fair Administrative Act, and also under the Common Rules 2024, which are operationalized. The question that arises and which people are asking is whether Order 53 is still necessary.
What's your view on that?
Yes. My view is there is no problem in having Order 53 so long as people are able to comply with the procedural requirement. But I think the most expansive position is, because the court has said, there are instances where the court will only review the process. And there's instances where the court will review process and merit. So where do you want to come in?
Okay, now, if you take the view that it may be appropriate for us to maintain both avenues, that is under Order 53 and Article 23, for purposes of treating parties equally, not to appear to be discriminatory to parties, do you think it's high time the Order 53 ought to be relooked into for purposes of removing the prerequisites of leave and timelines?
I think that is a very good question, Judge. It is not the responsibility of parties, or let me say, it is not the responsibility of the court to say you should be treated equally. It is your responsibility, because you have been given an opportunity to come either within the constitutional provisions. But if you opt under the JR, there is no responsibility on the court to say, because you have come under Order 44, you have been treated unequally against a person who had come under 23 and 47 under the Fair Administrative Actions Act. The opportunity is there. It is the parties to choice. If there is reason to get rid of Order 53, it is not for the judges, it is not for the commission. That is the work of the Honorable Attorney General.